I'm criminal defense attorney Aaron J. Boria. Right now I'm walking out of the 34th District Court in Romulus. My client was arrested for driving on drugs and drunk driving. Police officer amended the ticket to also add reckless driving. All charges have been dismissed and my client is a free man. So what happened was my client was stopped for running a red light and for running a stop sign. 2 civil infractions does not equate to reckless driving, even if the officer saw what he claimed to have seen. When my client was stopped, he simply explained that he was tired and missed the light and the sign. The officer ordered him out of the car and had him do field sobriety tests. He did okay on them, but the officer was convinced that my client had either been drinking, on drugs, or both, so he was arrested for it. When the state lab results came back, the state did not have enough evidence to go forward with the case. So they couldn't go forward with the drunk driving or the driving on drugs. So then the officer amended the ticket to add reckless driving, I guess to just try to stick my client with something, which is ridiculous. But so that's what he did, and I wrote a motion stating essentially that 2 civil infractions does not equate to reckless driving, where they have to show a willful and wanton violation of the traffic laws in such a way that it's likely that you're going to cause harm to somebody. I discussed the matter with the prosecutor before even filing that motion, and she agreed to dismiss. So my client walked out of court today. No criminal charges, no probation, no jail time, no loss of license. He's feeling pretty good, and so am I. So if you've been charged with driving on drugs, drunk driving, reckless driving, whatever, give me a call. I'm Aaron Boria, and you can reach me at 734-453-7806 or shoot me an email at borialaw@gmail.com. I am happy to fight for you. In any drunk driving or any driving on drugs case, the prosecutor is going to have to submit some type of scientific evidence. This is going to be evidence from either a data master, which is like a breath test, or from a blood test. In this particular case, we were dealing with a blood test. Blood was taken from a hospital and it was sent to the state crime lab. When you're dealing with a blood test, you want to make sure that, first off, is there enough of the substance there to say that they're even measuring something, or is the machine maybe detecting nothing and providing what a lot of people would call a false positive? We also want to make sure that the quality of the test is good, and we want to make sure that the test is performed properly. If it's not, then this evidence is never going to go to a jury for them to decide, because they would be basing a case on garbage evidence. So in this particular case, the prosecutor did not have enough good evidence to go forward to say that my client was either under the influence of alcohol or intoxicated somehow by drugs. And as a result, that charge had to be dismissed.